Welcome back, Consumer Law 101 viewers. We are here for our second video in our advanced video series. This video is entitled The ABCs of the FDCPA Part 2, Important Terms, Definitions, and Standards. As always, I'm your course instructor, Attorney Aaron Swift, and I am the Swift Law North CEO and Managing Partner. We start with our agenda. We're talking about the important terms, definitions, and standards. So first, we're going to review the term consumer debt in more detail. We're going to talk about the least sophisticated consumer standard, the strict liability statute and what that means, and that it's a civil statute with a private right of action. We're going to talk about consumer best practices. All right, so we did talk about the what in the previous video about consumer debt, but I want to go into it in more detail because this is actually a really important distinction and it's a threshold question that must be answered to make sure that this law applies at all. So now remember, it's incurred primarily for personal, family, or household use. So, sounds pretty easy to understand, but just think about that was. Of course, it's groceries, it's gas, it's swimming lessons for the kids, anything for your family, personal, gym classes, at, educational expenses, entertainment, a whole host of things. And as I did talk about, it doesn't require an actual extension of credit or a voluntary transaction. That was fought over for a long period of time in this law, but then they recognized something like a medical debt. Of course, there should be protections, and that didn't involve, a prearranged contract between, two parties to extend credit. For the most part, for it to be collected, it has to be delinquent, past due, and collections are in default. I mean, it kind of makes sense, to that degree, because remember, going back to the who, it only guards against the actions of third-party collectors or debt buyers. So they only really get the debt, of course, if it's delinquent, past due, and collections are in default. Now, that's different in some states. For example, where Swift Law South, as we call it, is based, the flagship firm. In Florida, we have a first-party FDCPA statute called the FCCPA. It's a sister statute that protects much of the same things, but it also guards against first-party creditor actions. So, for example, that would be if Capital One is collecting its own debt, the FCCPA applies versus, in that case, the FDCPA would not apply. But again, in this case, we're talking more about the federal statute, the Fair Debt Collection Practices Act. So generally speaking, the consumer debt is going to be in default, delinquent, past due, or in collections. These are some things that are not consumer debts, and these issues have been clearly litigated. Child support obligations are not consumer debt, so the protections of the FDCPA do not apply. Professional certifications that are paid by an employer are not consumer debts. Now, if a person takes educational courses on their own and incurs the debt, then that's a consumer debt. Another important, kind of realm of things that are not considered consumer debts are tolls, parking tickets, speeding tickets, anything that could be owed to like a municipality in terms of a fine related to yard work or code enforcement fees. Those things are not considered consumer debts. So again, this is covered in brief in last video, but it's really important because this is always a threshold question under the FDCPA, which is it a consumer debt? All right, so let's talk about another standard. It's called the least sophisticated consumer standard. Now you can talk about, you have the most sophisticated consumers up here. Maybe those are the judges. You've got hopefully lawyers somewhere up here. And then we're talking all the way down to the standard that's called the least sophisticated consumer. And, all jokes aside, we want to protect the gullible, the non-intelligent, just as much as the shrewd and the intelligent. So we design these laws to protect these least sophisticated consumers. So what you kind of look through is when you're talking about a debt collection action to decide if it's deceptive or harassment, you should really be looking through the lens or through the eyes of this least sophisticated consumer, and that's someone that's inexperienced, untrained, and sometimes credulous. You know, unsophisticated and least sophisticated, kind of describes what is some courts call this hypothetical consumer whose reasonable perceptions will be used to determine if collection messages are deceptive or misleading. So they still have a quotient of reasonableness. It protects against bizarre idiosyncratic readings of the law. But again, we want to talk about when we're looking through action. So if you are experiencing conduct from a debt collector, you don't have to necessarily always think, am I harassed here or am I being deceived? The question is, would the least sophisticated consumer be harassed or deceived? Okay, another important standard under the FDCPA is that it's a strict liability statute. So what that means is it doesn't require knowledge or intent to be held liable. So for example, if a debt collector sends a debt collection letter and it's asking for a fee that's not allowed, so it's collecting an amount that's too high, even if the debt collector thought the fee was allowed, but it's not, they're still held strictly liable. If you think kind of some law school issues, there's actus rea and there's mens rea. Those are Latin terms. For actus reus, there's an action, something that violated a law or a standard. And the mens rea is a mental state, was their intent. And most crimes, most, violations must require both of those things, a mens rea and an actus rea. Here, under the FDCPA, we're saying we're not going to require mens rea. This is too important. We want to protect consumers, even if there are sometimes honest mistakes or mistakes of belief in law or fact. We still have to protect the consumer in those instances. So it's important to know that if you're looking through the least sophisticated consumer's eyes, and also there's a violation that even if it's not intentional, that can still be held liable. Okay, so what are consumer best practices in this area, and how do we tie it into kind of the this next stage, the important standards, terms, and definitions under the FDCPA? Well, first of all, the FDCPA allows a consumer to sue debt collectors or junk debt buyers in a civil action. We're going to have a lot more information on that in our pro videos 1 and 2. We're talking about the secret powers of the FDCPA and some really amazing case examples under the FDCPA. But as long as you have a base understanding about the reasons behind it, as well as you're building upon this base of knowledge with the important terms, definitions, and standards, you'll be better prepared to deal with debt collectors and to, respond to them. And if then you've been harassed and to look through the standard of the least sophisticated consumer, and also realize that it doesn't even have to be intentional, reach out because you could be entitled to thousands of dollars, and the collector defendants would have to pay your attorney's fees and costs. As always, if you have questions, want more educational content, visit consumerlaw101.com. And for more information about litigation or how the FDCPA can be used, visit swiftlawnorth.com. Thanks.